Hello all, this is our second video, and in this video we'll be trying to continue the previous discussion. And in the previous um, video we discussed about order 1 to 6, very important. Order 1 to 6 we completed. Now we are trying to discuss uh, the procedure of civil suit from production of documents up till the framing of issues. What happens when documents are produced before the court by the parties as per order 13? After that, what happens? Examination of the parties will happen, and first hearing as per order 10. Next, discovery of documents and inspection of such documents, and any admissions by whom? Admissions by the parties. If they want to admit something related to the suit, and in order to close the suit early, then such admissions will be verified by the court and will be considered for the pronouncement of judgment and framing of or passing the decree. Next, after that, framing of issues by the court on whatever admissions they have done. Framing of issues will be done by the court. This is the very important slide that you have to keep in your mind. Next, let us go order 13. Order 13 speaks about production, impoundment, and return of documents. What do you mean by this? Here, very simple. Parties have to produce the documents. Second, impoundment means court, if it feels that it wants to keep certain documents, it can order for impoundment. That is very important. And after that, it can return the documents, return to the parties. When it can be returned, so that will learn in the upcoming slides. Next, original document. So what does this order speaks about? The order 13 speaks about original submission of original documents by the parties. They have to produce original document, and rejection of irrelevant documents. Court has the right to reject the irrelevant documents at any stage of the proceedings. Next, endorsement on documents admitted in the evidence. So endorsement admitted in the evidence. So that is very important. In the suit, the following particulars has to be mentioned. What is that? Endorsement ಅಲ್ಲಿ ಏನಿರಬೇಕು, ನಾವು ಏನೇನು ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದೀವಿ, ಏನನ್ನು ಮೆನ್ಷನ್ ಆಗಿರ್ಬೇಕು ಅಂದ್ರೆ, it has to speak about the number of the document, title of that particular suit. Okay. Next, name of the person producing such documents, name of the person producing such documents, and date on which it has been produced, and statement of its having been admitted. Nan submit madini anna statement to kodbekagate. This is the endorsement that has to be submitted to the court, and at the end it has to be duly signed. Okay, endorsement shall be signed by the judge. All right. Next, endorsement on documents rejected. Reject ಆಗಿರುತ್ತೆ certain documents as per rule 6. Then what happens? If it is inadmissible, if it is irrelevant document, then court can, that is judge can reject. He has the power to reject the inadmissibly documents. If it is irrelevant to the suit, then it can be rejected. Next, recording of admitted and return of the rejected documents. Every document which has been admitted in evidence, if it is admitted, document admit agide andre, it forms the part of the record of the suit. It forms the part of the records of the suit, and such documents which are not admitted, it is not part of the record. It is rejected, simple, and it is returned at the end. It is returned to the parties. Okay. Next, court may order any document to be impound. Impound antandre, it can tell. Rule 8, very important. Order 13 or rule 8, it tells that court has the power to keep the document in its custody. See, custody. That's it, very simple. Next, return of admitted documents. Yavaga return madbodu? When can it return the documents? Court can return when suit is decreed. Decree agide, judgment agide, decree agide. So what is the use of keeping the documents? It can return it. Next, appeal is not allowed. No appeal can be entertained, then it can return. And appeal is allowed. Appeal allow ಇದೆ, but the parties have failed to appeal in a specified time, then it can return. So these are certain criteria or conditions. First one is very important. After the suit is been decreed. Next, Order 13 ಆಯ್ತು. Now we are discussing order 10, examination of parties by the court, that is first hearing. ಎಷ್ಟು rules ಇದೆ? 1 to 4 rules ಇದೆ. What is that? Order 10 ಅಲ್ಲಿ ಏನು ಹೇಳುತ್ತೆ? First thing that court does is it asks whether the parties admit or reject. Admit ಮಾಡ್ತೀರಾ ಅಥವಾ deny ಮಾಡ್ತೀರಾ? Whatever is told in the pleadings by the pleader, do you plaint ಅಲ್ಲಿ ಹೇಳಿರೋ ಪ್ರಕಾರ ನೀವು ಅಡ್ಮಿಟ್ ಮಾಡ್ತಿರೋ ಇಲ್ವೋ ಅನ್ನೋದನ್ನ ಕೇಳುತ್ತೆ. ಸೊ ಬೇಸ್ಡ್ ಆನ್ ದಟ್ written statement is filed. Correct. Court shall record such admission and denial. So plaintiff ku kelutte, defendant ku kelutte. Correct. So admission of the claims made, allegations made in the civil suit. So if they admit it and if they accept it, and adenavate easy proceedings aate, bega mugdogutte proceedings. If they don't accept, then what happens? They start presenting their version of stories, whatever it's related to the suit, right? Next, direction of the court to opt for any mode of alternative dispute, ADR. So court has also the duty to advise the parties to go outside the court and get it settled. Is also there. Order 10 ಅಲ್ಲಿ rule 1A. So A 1A ನೆನಪಿರಬಹುದು. 1A ಅಂದ್ರೆ ADR, A for ADR. You can just remember. Next, appearance before the conciliatory forum. So advice matter prakara, they can go and approach the conciliatory forum, and if they say failure ಆಯ್ತು ಅಂತಂದ್ರೆ, conciliation failure ಆಯ್ತು ಅಂತಂದ್ರೆ, again they have the right to come and appear before the court. ಅಲಾಗಿಲ್ಲ ಸ್ವಾಮಿ, ನಾವು ನಿಮ್ಮ ಹತ್ರನೇ ವಾಪಸ್ ಬಂದಿದ್ದೀವಿ, ನೀವೇ ನಮಗೆ ದಾರಿ ತೋರಿ ಅನ್ನೋ ತರ. Next, oral examination of the parties. What do you mean by oral examination of the parties? So it is first hearing, it shall do the oral examination. Oral examination shall be recorded. So oral examination of any party. So answer any material question related to the suit. They have to answer the questions related to the suit. Simple. Okay. Next, substance of examination to be written. As I told earlier, it has to be written. Oral examination ಆಯ್ತಲ್ಲ, ಅವಾಗ ಅದೇನ್ ಮಾಡ್ಬೇಕು? It has to be reduced to writing. By whom? Judge has the role, right? Judge has the duty to make sure that it has been reduced to writing. Dictation ಕೊಡ್ಬೇಕಾಗತ್ತೆ court officers ಗೆ, so that they will reduce into writing. Next, consequences of refusal or inability of the pleader to answer. Pleader ಅಂದ್ರೆ advocate answer ಮಾಡಕ್ ಆಗ್ತಿಲ್ಲ. Advocate is not in the position to answer. Then whose responsibility it is? Party ne ಬರ್ಬೇಕು ಅವಾಗ. Party has to come and he is ought to answer before the court, and it should not cross more than 7 days. Very, very important. Next, settlement of issues. So settlement of issues ಅಂತಂದ್ರೆ, parties have agreed upon certain issues. ನನ್ನ ನಿನ್ನ ಮಧ್ಯೆ X ಮತ್ತೆ Y ಮಧ್ಯದಲ್ಲಿ, ಹೌದಪ್ಪ ನಿನ್ನ ನನ್ನ ಮಧ್ಯೆ ಇದೇ ಇಶ್ಯೂ ಇರೋದು, ಲೆಟ್ ಅಸ್ ಸೆಟಲ್ ಅಂತ ಅಗ್ರಿ ಮಾಡ್ಕೊಂಡ್ರೆ, the court will start with the next level of proceedings. Hearing, examination of witness and arguments, and finally passing of judgment and decree. Next, order 11 speaks about disclosure and discovery and inspection of documents. Disclosure, discovery, inspection and inspection of the documents. 1 to 6. Disclosure and discovery of documents. Rule 1, what does it tell? It tells list of documents, photographs of that, photocopies of that has to be produced, and documents referred and relied on the suit by the plaintiff in the plaint. ಯಾವ documents rely ಮಾಡಿದರೆ ಅದನ್ನ ಮೆನ್ಷನ್ ಮಾಡಬೇಕು. And relating to any matter in the question. Okay, documents relating to any matter in the questions in the proceedings. Are related documents ಮಾತ್ರ ಅವರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಬೇಕು. Okay, next, so plaintiff shall obtain a declaration on oath. That means all documents, whatever I have produced, it is in my possession, my control and my custody ಅನ್ನೋದನ್ನ ಅವ್ರು ಹೇಳಬೇಕಾಗುತ್ತೆ. Plaintiff shall not be allowed to rely, they are not allowed to rely on document which is not initially disclosed. ಈಗ ಡಿಸ್ಕ್ಲೋಸ್ ಮಾಡಿಲ್ಲ, ಮುಂದೊಂದು ದಿವಸ ಬಂದ್ಬಿಟ್ಟು ಡಾಕ್ಯುಮೆಂಟ್ ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ ಅನ್ನೋದು ಆಗಲ್ಲ. They have to take the leave of the court. If court is satisfied, why didn't they not produce before when it was asked? ಅದನ್ನೆಲ್ಲ ಅವರು ರೀಸನ್ಸ್ ಕೊಟ್ಟು ಅವಾಗ ಅವರು ಅಡ್ಮಿಟ್ ಮಾಡಿಸ್ಕೊಳಕ್ಕಾಗುತ್ತೆ ಮಾತ್ರ. Okay, shall be see reasonable cause for non-disclosure has to be given. Non-disclosure has to be given. Next, defendant shall file the list of the documents, whatever he is producing, the photocopies of the documents, he'll be producing it. All right. Next, discovery by interrogatories. What do you mean by interrogatories? Here, this is very important. Interrogatories, here, section 30, order 11, rule 1 to 11. Okay, very important. They are the formal written questions ಕೇಳ್ತಿದ್ದಾರೆ to the opposite party. Opposite party, with the leave of the court, with the permission of the court, they are asking these questions to the opposite party so that they give reply within 7 days. Yeah, other questions related to what? To ascertain the truth. In problem, what is the real content or gist of that particular suit? Why have you initiated the suit? What are the reasons? What do you seek from me? Reasons to understand the case, of the opposite party. Right. Next, to understand the strength of their own case, right? Next, admission and denial of the document. Yavaga admission agutte, yavaga denial agutte. So each party shall submit a statement of admission or denial of the documents. Within 15 days it has to be submitted. We accept or we deny anta stating whether such party was admitting or denying, whether they are admitting or denying, whether correctness of the document correct ಆಗಿಲ್ಲ ಅಂತ ಹೇಳಬೇಕಾಗುತ್ತೆ. ಇಲ್ಲಾಂದ್ರೆ that document doesn't exist at all ಅಂತ ಹೇಳ್ತಾರೆ. ಇಲ್ಲ execution of the document related ಆಗಿರ್ಬೋದು, issuance of the document ಆಗಿರ್ಬೋದು, custody of the document ಆಗಿರ್ಬೋದು. These are the certain grounds for admission or denial. Okay. Next, production of document, rule 5. Production of document, rule 5. Court may order at any time during the pendency of the suit to produce certain documents which is in possession or power of the party. So this is the power of the court. Rule 5, very important. Rule 5, order 11. You have to keep in your mind. Court's power to ask for production of documents. Next, electronic records, rule 6. Rule 6, order 11. It's like audio or video content related to the suit. If they need, they can ask for the production of the same. If they are not able to produce it, in the sense they can take the printouts of it, printout of the electronic records. Also pen drive, so they can give the hard copy of it. Likewise. Next, admissions. Order 10 ಆಯ್ತು, order 11 ಆಯ್ತು. Now we are in order 12. Order 12 speaks about admissions. Why is it important? Admissions are very important. It is like helps for the speedy disposal. If parties agree, yes, X tells Y has to give 10 lakh to me and he has initiated the suit. Mr. Y, X has initiated the suit. And when it comes to Y, if Y accepts, yes, ಹೌದನ್ನು ಕೊಡ್ಬೇಕು ಸ್ವಾಮಿ ಅಂತ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಬಿಟ್ರೆ ಮುಗ್ದೆ ಹೋಯ್ತಲ್ಲಿ. ಟೈಮ್ ಕೊಡುತ್ತೆ ಕೋರ್ಟ್ ಒಂದ್ ಸ್ವಲ್ಪ ದಿನ, ಅಷ್ಟೊಳಗಡೆ ಕೊಡ್ಬೇಕಾಗುತ್ತೆ. ಇಲ್ಲ ನಾನು ಕೊಡಂಗಿಲ್ಲ ಹಂಗೆ ಹಿಂಗೆ ಅಂತ if Y is telling, then suit will get dragged. So admissions plays an important role in speedy disposal of the cases, and it is not compulsory. It is court's discretionary power to give judgments based on the admissions made by the party. Parties admit ಮಾಡಿದ್ರು ಅಂದ ತಕ್ಷಣ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡಲೇಬೇಕು ಅಂತ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ಸತ್ಯತೆನ ತಿಳ್ಕೊಳ್ಳಕ್ಕೆ ಕೋರ್ಟ್ ಪ್ರಯತ್ನ ಮಾಡಬೇಕು. So definition of admission is given in section 17 of Indian Evidence Act. Very important. Okay. So order 12, rule 6 speaks about admissions. So next, rule 1. party to suit should give in writing that he admits the truth or any part of that particular suit. Any partial ಇದು ಇದರಲ್ಲಿ ಅರ್ಧ ಸತ್ಯ ಅರ್ಧ ಸುಳ್ಳು ಅಂತಾನು ಹೇಳ್ಬೋದು. Partial ಅಥವಾ complete acceptance is also allowed. Rule 2 states that issue a notice to other party regarding the admission or refusal of the document submit ಮಾಡಿರೋದು ನಾನು ಒಪ್ಪಲ್ಲ ಅಥವಾ ಈಗ ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ಯಾವುದೋ ಒಂದು ಕಾಂಟ್ರಾಕ್ಟ್ ಎ ಮತ್ತೆ ಬಿ ಮಧ್ಯ ಆಗಿರುತ್ತೆ ಅಂತ ಇರುತ್ತೆ ಕಾಂಟ್ರಾಕ್ಟ್ ಅಲ್ಲಿ. ಎ ಹ್ಯಾಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಬಿಫೋರ್ ದ ಕೋರ್ಟ್ ಎಗೇನ್ಸ್ಟ್ ಬಿ ಅಂಡ್ ಬಿ ಕ್ಯಾನ್ ಅಕ್ಸೆಪ್ಟ್ ಇಟ್ ಆರ್ ಡಿನೈ ಇಟ್ ವಿತ್ ಇನ್ 70 genuinity. ಎಸ್ ನಾನು ಮಾಡಿದೆ, ದಿಸ್ ಬಿ ಇಸ್ ಮೀ, ನಾನೇ ಆ ಬಿ ಅಂತ. ವಿತ್ ಇನ್ 7 days he has to admit or reject it. Next, deemed acceptance ಅಂತಂದ್ರೇನು? ವೆರಿ ಸಿಂಪಲ್. ಅದರ್ ಪಾರ್ಟಿ ಡಸ್ ನಾಟ್ specifically deny no ಮಾಡಲ್ಲ, nor he admits it, neither admitting nor denying, then it is considered, it is deemed acceptance. admit ಆಗೋಗಿದೆ ಅಂತ ಅರ್ಥ. ಸೊ ಸುಮ್ಮನಿದ್ರೆ ಅದು ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ದಂಗೆ ಅನ್ನೋ ತರ. ಇಟ್ ಇಸ್ ಲೈಕ್ neither accepted nor denied, it is considered as deemed acceptance. Okay. Next, rule 4 clarifies that admissions made by virtue of notice cannot be used against the parties. It cannot be used against the parties. Admissions ಏನೇ ಮಾಡಿದ್ರು, it cannot be used against the party for any other case. This is very important. Other proceedings, any other proceedings, any other suit. ಆ ಸೂಟ್ ಮಾತ್ರ applicable admission. No, it is not applied for no other suits. Next, order 12, rule 6. So as I told, very important, power to make judgment based on the oral admissions or written admissions made by the parties. So court has the power to make the judgment based on the admissions made by the parties. Next is one case, Uttam Singh case, very important, Uttam Singh case 2000. In this case, the court had passed the judgment based on the admissions made by the plaintiff. Okay, so this is very important case. So again, see, this is one point. Admissions based on the judgment based on the admissions cannot be claimed as matter of right. So as I told, it is discretionary power of the court. Court may accept or reject that particular admissions. Correct. Next, what is the difference between admissions and confession? Confession might lead to conviction. Very important difference. Conviction agbodu, but admissions cannot be the ground for conviction. Conviction agak sadhyane illa. So confession usually criminal cases. Admissions you use in civil suits. Okay. So last order for this video, order 14, which speaks about framing of issues by the court. So you have 7 rules in this. Very simple. Issues, the court has to frame the issues. And next, judgment has to be given on all the issues. ಯಾವ issues frame ಮಾಡಿದೆ court, ಅದರ ಬೇಸ್ ಮೇಲೆ ಆ ಎಲ್ಲ issues ಮೇಲೆ judgment ಕೊಡಬೇಕು. It is the duty of the court. And materials from which the issue has been framed, facts, the material facts on which the court has framed the issues has to be checked. Next, court may examine the witness and documents before framing the issues. This is very important. Witness check ಮಾಡಬೇಕು, witness na examine ಮಾಡಬೇಕು, documents na examine ಮಾಡಬೇಕು before framing the issues between parties x ಮತ್ತೆ y ಮಧ್ಯದಲ್ಲಿ issues ಏನೇನಿದೆ, ಇವನು ಎಷ್ಟು ದುಡ್ಡು ಏನಾದ್ರು ಕೊಡಬೇಕಾ, is it a money suit or is it related to property. Likewise, it has to check the nature of the claims and then frame the issues. Next, power to amend and strike out the issues. Court, this already we have learned, court has the power to amend or strike out any issues at any point of time, and question of fact or law may be stated in the issue upon the agreement between the parties. Parties have agreed related to the facts, and then such facts can be mentioned in the issues. Court, if it is satisfied that agreement was executed in good faith, it can pronounce the judgment. So if court finds that agreement agiradi yadu, question of fact and law, if it is found that such agreement is done on a genuine basis, then it can pronounce the judgment. Very simple. So today in this class, in this video, we covered production of documents by parties, that is plaintiff or defendant, order 13. Next, examination of parties and first hearing, order 10. Discovery of documents, inspection of documents, order 11. Next, admissions, the role of admission, importance of admissions, order 12. Next, framing of issues, how court has to frame the issues, order 14. So this is completed. So I hope you got the clarity about all this. Orders, we are going fast because you have to get it revised as soon as possible. So thank you, all the best, study well.